Okay, let's make a start. Good morning, everybody. I hope you're all well. Thanks very much for making the time to join our session today, and welcome to my spare bedroom. I'm Paul Carberry. I'm a partner in the pensions team at Gowling, and I'm joined today by my colleague Liz Wood, a principal associate in the team.
Hi, everybody.
Together, Liz and I will take you through the elements of the Pension Scheme Act that are most relevant to employers. As set out on the slide, it wouldn't be an overstatement to say that the Pension Schemes Act has created a new regulatory landscape for UK pensions, so plenty of food for thought for employers. But before we dive in, just a few housekeeping points if I could, please. We'll be talking today for around 30 minutes, leaving 10 to 15 minutes for questions. So could I please encourage you to use the Q&A function at the bottom of the screens. Now the kids are back at school, we're not anticipating any Zoom bombing, but if anything unfortunate does happen, please bear with us. And then finally, and there'll be another reminder at the end, a feedback form will be coming around after the session. We really welcome your comments. So that's probably enough padding from me. So let's make a start. Let's move on to the agenda.
Sorry, there might be a slight delay on the slides today, okay. So just bear with us for a second. Not quite sure what's happening, but bear with me. There we go. There we go.
Bingo. Thanks, Liz. So we'll kick off with a brief overview of the Pension Schemes Act. It covers an awful lot of ground. We'll give you the headlines on each. We'll then touch on the strengthening of the Pensions Regulator sanctions regime. I'm sure you've heard a lot about that. There's criminal sanctions and civil sanctions. We'll then look at the increased powers around corporate transaction oversight for the regulator and additional information gathering powers. And there was some new information released on that last week, which we can update you on. There'll be updates to the contribution notice regime. And again, there's some more information and draft regulations made available last week. We'll touch on the new scheme funding regime. And then finally, to wrap it all up, just a couple of practical steps that you can start to take now. I'll just hand over to Liz for the overview.
Thanks, Paul. As I say, we might just have a bit of a delay. Here we are with the slides, but let's get going. Okay, well, this is the most significant pensions legislation we've seen since the Pensions Act 2004 introduced the Pensions Regulator in 2006. And we've since then had the Moral Hazard Framework, which is the regulator's existing powers to impose, amongst other things, contribution notices and financial support directions in relation to defined benefit pension schemes. And from a pensions lawyer's perspective, the Pensions Schemes Act 2021 is a pretty seminal piece of law. It covers a wide variety of areas and which will have the potential to really change the UK pensions landscape, as Paul's alluded to, albeit this will change over time. In a number of areas, the Act really depends on the regulations and further consultation in order to really put the flesh on the bones of what the law is trying to do here. Now, we're going to focus today on the aspects shown in light blue on the right of the slide, the new criminal and civil offences introduced by the Act, alongside the regulator's other new powers. Okay. So let's take a step back for a moment, if I can get my slide on the right place. There we go. So I think it's really helpful to just take a step back and think about why we've got to where we are in terms of the new regulatory powers. And a lot of this has come from the high profile corporate failures that we saw back from 2016 onwards. So BHS, British Steel, Carberry, those kinds of corporate failures, and the impact for the pensions members in the DB schemes associated with those employers. Now, those failures were subject to intense media scrutiny as well as government consideration, including select committee investigation. And the government's, following various reviews, ultimately concluded that the regulator had insufficient powers within its existing armoury, leading to a commitment to bolster TPR's powers in light of these types of corporate failures. And the reason why I mention these is not only to set the scene, but also because I think these examples are really helpful to bear in mind in terms of how the regulator is going to look to prosecute in the future, which we'll come on to later. Okay. Now, the policy intent sitting behind this is broadly what the pensions industry has expected in policy terms following the government's stated intention here. And the proposed changes are focused on strengthening the role and functions of the regulator, making it more proactive, more responsive, more effective as a regulator. So fitting into that regulator drive to be clearer, quicker, tougher. And we're absolutely seeing that in practice already. Regardless of whether the Act has come into force or not, we have seen in the last 18 months, 2 years, the regulator absolutely stepping up and being much more interventionist. We've seen that within the Gowling pensions team. We've also seen that across the pensions industry. And that might be anything from TPR communications that we've seen with trustees and sponsors of DB schemes, setting out its expectations, asking questions, but also in the fact that the regulator more regularly expects a seat at the table. So it wants to know what's going on, and sometimes it wants to be absolutely directly involved in those conversations. And sometimes we'll also see the regulator asking for information about what's happened in the past in order to understand what's happened in relation, for example, to corporate transactions, why trustees and sponsors have made the decisions that they have. So who will this Act affect? Well, in terms of the regulatory changes that we're looking at, it's a very wide range of stakeholders. Obviously, sponsors of occupational DB pension schemes, trustees of occupational DB pension schemes. We also think it will involve those involved in corporate transactions where a DB scheme is involved, but also interested parties more widely, and Paul will come on to that in terms of how the Act is drafted. It's a very wide remit there. But I'm now going to hand over to Paul, who's just going to start talking about what these new criminal and civil offences are.
Okay, thanks Liz. The strengthening of the sanctions regime for the regulator. Just move on to the next slide as well, please Liz. Okay, so what have we got by way of overview? Well, clearly the extension of these sanctions, it's intended to support TPR's enforcement role, so tougher regulator. And key within the new regime, the strengthening of the new civil and criminal sanctions. As I alluded to earlier, I'm sure you've all heard about that. That was the big headline grabber throughout the Pension Schemes Act's development. You know, and within the headlines, 7-year prison sentence, £1 million fine, so potentially quite alarming. But let's be clear, the new sanctions are intended to be directed at unscrupulous directors and companies. That is the primary focus, as Liz set out in the policy intent. Although there are some concerns that some of the changes might impact more widely on day-to-day corporate activity. So that is a concern. Throughout the presentation, we'll suggest how much of a concern that should be for the majority of employers. We'll just now move on to the detail. So the criminal sanctions first.
Oh, sorry, Paul.
Keeping me guessing. Thanks, Liz. So there's 2 new key criminal sanctions. First offence, avoidance of an employer debt. So that's quite broadly drafted. And who's potentially subject to that sanction? Well, any person. So that could be any of you. It could be Liz. Even worse, it could be me. But this is all starting to feel a little bit uncomfortable. So let's have a look at the potential punishments. Well, an unlimited fine or a 7-year prison sentence. That's not making me feel any better. I think we're all beginning to fidget in our seats a little. But before we panic, let's look at the acts that are intended to be caught by this sanction. An act or course of conduct that prevents the recovery of an employer debt. The person who undertook that act intended the act to have that effect. And the person who undertook that act didn't have a reasonable excuse. So you think day to day, that's going to capture quite a narrow range of activity. So maybe this isn't quite as alarming as it first sounds. So that's the first criminal sanction. Let's just move on to the second one, please. Okay. So the second offence, this is conduct risking accrued scheme benefits. Well, if anything, that's even more broadly drafted than the first sanction, sorry, the first offence. Again, it's targeted at any person potentially, and the punishments are pretty onerous. But what do you have to do to be captured by this sanction? It's an act or a course of conduct or a failure to act that detrimentally affects in a material way the likelihood of accrued scheme benefits being received. And again, the person undertaking that act must have known or ought to have known the act would have that consequence, and the person didn't have a reasonable excuse for undertaking that act. So you can look for circumstances at the extremes that might be captured by that condition or those conditions. The majority of day-to-day situations are not going to be caught by that. So hopefully that's a little reassuring. Can we just move on to the financial penalties, please, Liz? So the financial penalties, they sit alongside the criminal sanctions. £1 million fine, so again, a big headline grabber and potentially concerning. But let's look at the type of activity that might result in £1 million fine. A person has knowingly or recklessly provided false or misleading information to the regulator or the trustees, or they fail to comply with a contribution notice, with the notifiable event rules, or with a new duty to notify the regulator about certain events. So I have to say, from my point of view, they are the type of breaches that I would expect there to be a sanction for. It doesn't feel, again, the day-to-day typical activity from a corporate is going to be too heavily impacted. Thanks, Liz. That said, for balance, that there clearly are some concerns around the new requirements. The new criminal offences, as I said, do apply to any person or to any act or failure to act. There's no getting away from the fact they are extremely broadly drafted. And that was clearly the intention. The government didn't want any loopholes, but there is a worry that some routine and legitimate business activity may be caught by that. But I have to say, I think that's going to be relatively infrequent. There's also the concern about the reasonable excuse. Well, what is that? What is reasonable? How do you know that your behaviour is appropriate and not going to be subject to sanction? Under the Act itself, what a reasonable excuse was not clear, but we now have a little more information on that, and Liz will come on to that in a moment. And I think there was an overriding sentiment that the new requirements would be an impediment to business activity, to transactions, possibly in extreme circumstances, but I have to say, I don't see it being a material concern for the majority of employers. Just move on to the next slide, please, Liz. So the government was aware of all these criticisms throughout the Act's development. So how did it respond? And I think this is a really helpful statement in terms of policy intent. The new criminal sanctions will be limited for the vast majority of responsible employers. The greatest impacts will be on the small number of employers evading their responsibilities. The TPR will be able to hold them to account more effectively. So really helpful and clear statement about what the policy intent is. But as of last week, we had the draft regulator guidance about how they intend to react to that statement and to that policy. And let's see if the two dovetail. So over to Liz.
Thanks, Paul. Yeah, so we helpfully have just had in the past couple of weeks, very helpful for today's webinar, a draft policy outlining its proposed approach to the investigation and prosecution of these new criminal offences. And I think this sheds invaluable light on some of the concerns that have been raised by the pensions industry in relation to the Act and how these offences might be dealt with by the regulator in practice. And this is part of a 6-week ongoing consultation about how TPR expects to use its new regulatory powers. What I think is absolutely key in terms of what the regulator's focus is in this draft policy is the government's policy intention sitting behind these new powers to address serious, intentional or reckless conduct. It comes back to that background rationale I was talking about at the start of the webinar. And as such, the regulator has confirmed that its approach will be absolutely guided by that policy intention. It doesn't expect to change the kind of behaviour it investigates. Instead, it's going to draw on the fundamental change to its powers available through the new Act. So really, the regulator is looking to use these powers where the behaviour is sufficiently serious to warrant such intervention. To echo Paul's comments, a very small minority of employers who are reckless in relation to their DB pension schemes. So let's drill down in a bit more detail on what this new draft policy says. Well, there's quite a bit of useful content in there. It's only 12 pages long, but it includes areas of comparison and difference between the existing contribution notice regime and the new offences. We've got working examples of how the regulator might approach investigation and prosecution, and also a helpful confirmation that the regulator will consider material detriment in the same way that it would do for material detriment contribution notices. So we have guidance there around how the regulator would approach that second new criminal offence, LIN, that Paul was talking about earlier. What I think is particularly helpful is what the regulator has to say about reasonable excuse. So this is the point that Paul was mentioning, that this is in the Act, but we just didn't really have a context when the Act was passed into law in February about what exactly reasonable excuse would be for these two new criminal offences. And the regulator has confirmed that its focus when looking to prosecute either of these offences is whether the accused had a reasonable excuse. In terms of key considerations, the regulator says, well, starting point, all relevant factors will be taken into account in terms of establishing whether that reasonable excuse is met. But the regulator helpfully calls out 3 factors in particular as being significant in determining whether there has been a reasonable excuse for the act, the omission, the course of conduct. Firstly, this incidental or fundamental test on the right of the slide. So this is about looking at whether the detrimental impact on the scheme or the likelihood of scheme benefits being received was an incidental consequence of the act or the omission or the series of acts, or was it an absolutely fundamental necessary step to achieve the goal of the party in question? And the regulator says the more incidental, the more tangential it is, the more likely it is that the person's going to be able to show that reasonable excuse as against the offence. So an example that the regulator calls out would be, for example, an employer's business is harmed because ordinary business activity conducted on arm's length basis changes radically. So for example, a supplier or customer terminates a really large contract with that employer's business, and that has an impact on the DB pension scheme. So that would be an example of incidental impact on the scheme where reasonable excuse is likely to be shown. The second thing that the regulator says would be a key consideration from its perspective is the adequacy of any mitigation provided. And I think this is very consistent with what we see already around how the regulator would view things that impact negatively on a DB pension scheme. So what is the mitigation that's been put in place in relation to the scheme as a result of what is being done? And again, examples that we have in the policy include an employer granting security for the benefit of entities outside the direct employer covenant, but the security provided is subordinated to all present and future liabilities of the scheme. Another example is where an employer is supported by a group covenant, but that entity is sold to a buyer, ending that wider support from the group, and that therefore has a negative impact on the scheme because it doesn't have that wider support anymore. But in this case, for example, a combination of part of the sale proceeds is put towards the scheme, so that forms part of the mitigation, and possibly there's a provision of a guarantee from the buyer's group. And here again, the regulator says, well, there the mitigation might be considered adequate, and therefore the reasonable excuse statutory defence might be shown. The last point the regulator calls out is what happens if there was inadequate or no mitigation. So was there a viable alternative? So this is essentially looking at what's actually happening on the ground. And an example here is, well, if you might have an employer in distress, raising debt with prior ranking security to that of the scheme, but where that new debt is absolutely critical for the survival of the business, the regulator might take the view that actually there wasn't a viable alternative available. Again, reasonable excuse might be shown here because this was a life-saving situation for the employer in order to avoid its insolvency. And that ultimately would be a better outcome for the scheme. Some other considerations that the regulator would take into account would also be things like whether any statutory requirement to notify the regulator have taken place, any engagement with the trustees, what those conversations have been like, and whether the regulator has been engaged with more generally. So I think some really helpful guidance there that we've seen in that draft policy. But practically, what does that mean now? How to protect your position? Well, the reason you're probably on this webinar is to be aware of these new powers, let that inform your thinking and also your corporate governance going forward. Keep an eye out for the final form regulatory policy here, and also, of course, what the regulator does in practice. We do expect that there might be more management time and costs in considering these issues and engaging with the trustees and the regulator, but I don't think materially more. We expect those conversations to be taking place in any event. But I think what's really different here is just the importance of documenting decision making. In this new draft policy, the regulator says that those being investigated with a view to prosecuting these new offences need to be able to explain their actions, put forward cogent rationale for their reasonable excuse. And the regulator says this should be clear from contemporaneous records, such as minutes of meetings, correspondence, and written advice. So even if you're already having that ongoing engagement with trustees of DB pension schemes, ensure that any decisions and any advice received are absolutely documented so that you can evidence your thought process in the event of the regulator starting to ask questions. Okay, I'm now going to hand over to Paul, who's going to consider the new requirements to notify the regulator in relation to certain corporate transactions.
Thanks, Liz. The two elements to this section, the corporate transaction oversight and the additional information gathering powers that the regulator will have. So dealing with the corporate transaction oversight first, so what we have here, there will be a new requirement for employers to notify the regulator about certain events, and a requirement to submit a statement to the regulator and trustees of how certain events might affect the defined benefit pension scheme, so certain corporate activities. The statement that's issued to the regulator and to the trustees will need to be issued in advance of these events taking place. And within the statement, the employer will have to set out that they've given consideration to the effect that these transactions will have on the pension scheme, and set out what steps they will take to mitigate those adverse effects. It's worth bearing in mind that these additional provisions will sit alongside the existing notifiable events regime, so additional powers for the regulator. And this all goes to the regulator being quicker. It's able to get more information more quickly and then more readily intervene if it's necessary to do so. So what do we think of these new requirements? Well, to my mind, that the first two are essentially procedural. They are notifications about certain activities that a corporate is likely to undertake, so generally won't be too onerous. And I would say that the third requirement, they need to demonstrate in the statements what the issues are of the pension scheme and how you're going to mitigate those issues. I would say, again, that's what the vast majority of responsible employers are doing anyway in relation to material corporate activity. And which events do need to be notified? We're not entirely clear yet. We're waiting for the supporting regulations to come through, but we do have a good idea from the consultation and discussions as the app is being developed. We'll just come on to that now. So we're looking at things like sale of a controlling interest in a scheme employer, sale of a material proportion of the business or assets of a scheme employer, or the granting of security on a debt which gives it priority over the scheme's debt. So again, not day-to-day activity. Regulators not trying to get involved in every nuance of a corporate business, but these are big ticket corporate actions that could have a material impact both on the employer and on the pension scheme. So you can understand why the regulator and the trustees want early sight of events like this, so they can plan around them and engage sensibly with the employer. Okay, thanks, Liz. So how can you protect your position here? I think it might be better to think about how can you react to the situation. There isn't an awful lot you can do at the moment to protect your position as an employer, because we are waiting for the details, as I say, in secondary legislation and CPR guidance. That said, there are things you can do. I think the key amongst this is to continue to engage constructively with your pension scheme trustees in relation to any corporate activity you're undertaking. That said, you do need to start planning for potentially more engagement with the regulator in respect of certain material transactions. And bear in mind, there might be an increased timeline to transactions as you provide notifications and have exchanges with trustees and regulator. So these are certain steps you should be aware of. You start planning that into your timelines for future corporate activity. Okay, thanks, Liz. So moving on now to the additional information gathering powers. And again, these supplement the powers that the regulator already has, rather than he moves them and replaces them. You may be aware that the consultation around the information gathering powers was issued last week. Consultation runs until the end of April. And we also now have the draft regulations, which is really helpful because the direction of travel is much clearer. So what does it mean? What will the regulator now be able to do? Well, there'll be additional powers to require people to attend interview. There'll be additional powers to inspect premises, and there'll be ability to enter a wider range of premises. And to give all this teeth, the regulator will now have the ability to impose fixed and escalating fines on those individuals who don't respond to information requests. So a material uptick in the powers being granted to the regulator. But what will it mean practically? Well, I don't think we'll all be worrying about having to go down to Brighton on a regular basis for lots and lots of interviews. I don't think the regulator will be turning up our offices, stroke houses at the moment, to inspect our premises or to check advice or paper trails. But these powers will be used sparingly in important situations. But it is consistent with a much tougher regulator. And I think the headline here is responsible employers who engage constructively with trustees on an ongoing basis and regulator when required won't have too much to worry about. Okay, thanks, Liz. So just moving on to changes to the contribution notice regime. Just move on to the next slide, please. Thank you. Yeah, you'll be aware that there's already an existing regime for contribution notices, but by way of summary, the regulator has the power to impose a contribution notice requiring a particular target to pay an amount of cash to a pension scheme or to the pension protection fund, and this is used in very limited circumstances. Okay, thanks, Liz. But what are the changes? What are the new elements of the contribution notice regime? Let's say, to repeat, the regulator has very rarely imposed contribution notices to date. I don't think anyone expects that to change. But there is a recognition that the regulator faces hurdles in imposing contribution notices in certain circumstances based on the existing legal tests. That's because these tests are primarily focused on the impact an action has on a pension scheme rather than an employer, and evidentially that can be quite difficult for the regulator to demonstrate the test has been met. So to broaden the range of circumstances where the regulator can, where it's reasonable, impose a contribution notice, there are 2 new tests to be introduced, and these very much focus on scenarios which result in the weakening of the sponsoring employer. And we'll come on to those 2 events now. The first of the 2 new tests is the employer insolvency test. So the regulator can issue a contribution notice if, in its opinion, immediately after an act or failure to act, the scheme has less assets than liabilities, so the scheme is underfunded. And if a Section 75 employer debt had fallen due, that act or failure to act would have materially reduced the amount that would become recoverable. So essentially here, the regulator needs an ability to intervene where it's reasonable to do so, where assets are being put outside the reach of the scheme. Thanks, Liz. The second of the 2 tests, the employer resources test. So when can the regulator act here? Where there's been an act or failure to act that has reduced the value of the resources of the employer, and the reduction in those resources was material relative to the amount of the estimated employer debt. So again, a weakening of the employer covenant. The big question here is, how do you measure employer resources? Well, we've had some recent help on that. Further information, draft regulation and consultation around this was issued only last week. And while it's not clear it'll be accepted yet, the proposal is a normalised annual profit before tax basis will be implemented. So you look at that both before and immediately after an act or failure to act, and then the regulator can determine whether it's appropriate to intervene. Okay. Thanks, Liz. So what's the likely impact of all this? Well, in theory, it'll be easier in certain circumstances for the regulator to issue contribution notices. But what does that mean for directors and corporates? Well, I think day to day, again, not a huge amount of change, but clearly they will need to be aware of these new tests and take them into account when making financial decisions that impact on their business and then have an impact on their pension scheme. But fundamentally, if employers are able to demonstrate they've given due consideration to their actions, have recognised the impact their actions will have on their pension scheme, taken all reasonable steps to mitigate that, most employers were in a pretty good position to demonstrate it would not be reasonable for a contribution notice to be issued. There has been a suggestion that with the new contribution notice test being implemented, there'll be increased uncertainty for employers. There'll be a lot more applications for clearance. People will be nervous about what they can and can't do. To my mind, I think that's possible in the short term, but even then, I can't see a torrent of clearance applications being made. And certainly medium to longer term, I think when the rules of the game are clearer, the regulators set out quite clearly what's expected in relation to these tests. Employers and their advisors will be more comfortable with the landscape, and the number of clearance applications will be pretty consistent with what we have now. I'll just hand over to Liz for the scheme funding.
I just wanted to also flag the new requirement in the Act for defined benefit scheme trustees to put in place a long-term scheme-specific funding and investment strategy. Now, this is something that the regulator has been talking about for a number of years, particularly in relation to its annual funding statements, that expectation that trustees look at what the long-term aim for the scheme is and make sure that that takes into account integrated risk management approach, so taking into account the covenant of the employer, investment funding, using that joined-up approach, and setting the scheme's technical provisions in the triennial valuation accordingly. So although we've had that as an aspirational or good practice goal that the regulators talked about, this now is introduced as part of a statutory obligation. So all trustees of DB pension schemes must approach scheme funding in this way. What's particularly new here is that trustees of DB schemes will be required to report on this strategy to the Pensions Regulator in a new statement of strategy, so a chair's statement. And ultimately, if the regulator doesn't like the approach being adopted by the trustees, it can direct the trustees to amend it. So this is where we expect the heavy lifting of these new funding requirements to be found. That obligation on the trustees to both consider and put in place the strategy, to consult with the sponsoring employer when preparing the statement, but also to regularly review it. And failure to prepare the strategy and statement could result in a fine of up to £50,000. As we've seen with a number of areas of the Act, the detail sitting behind this long-term planning requirement, so specifics as to timings and content, is to follow. We currently expect this long-term funding target will be required for all scheme valuations from around March 2022, but that's yet to be confirmed and could possibly be pushed back. We've got a consultation expected on this scheme funding requirement later this year, and it sits alongside the new planned Code of Practice on DB scheme funding, which the regulators also expected to consult on later this year. So these new scheme funding rules are unlikely to come into force before the first quarter of 2022. That said, whilst it's not yet a statutory obligation, we do think that sponsors can and should be proactively engaging with defined benefit scheme trustees, confirm the current approach to integrated risk management and how that long-term funding target is set. And that can also act as a springboard for those conversations about, well, what is the long-term goal of this scheme in particular? It might shape the discussion on long-term funding and investment strategy, and also could be an opportunity to engage with trustees on, for example, risk transfer options such as buy-in, buyout, and other options. So Paul's going to finish now by just covering the next steps and the practical steps that you can take now.
Okay. Thanks, Liz. You probably gathered during the course of the presentation today, excuse me, while the Pension Schemes Act put in place the framework for the changes, a lot is expected. We've already had lots of draft guidance, consultations, draft regulations, and there will be more to come. With just 3 elements to really labour so corporates are aware of it in terms of their planning for the future. As Liz has alluded to, Part 2 of the TPR's consultation on the new defined benefit funding code is expected the second half of this year. Really important document in terms of how your funding obligations are going to change over the coming years. We spent a lot of time talking about the new regulator powers. This is the information gathering, the sanctions, the corporate transaction oversight. Well, we have a lot of the detail now. We're expecting these powers to take effect from autumn 2021. And then in terms of the funding obligations, it's valuations from 2022, where these changes are really on to bite. Thanks, Liz. And then just a final slide on practical steps you can take now. Well, you probably gathered that there's lots to consider here, an awful lot in the Act. But I do think generally for responsible employers day to day, there won't be too much impact on your corporate activity. That said, we do think there'll be an increased focus on corporate governance and how boards and directors manage their pension risk. So what can you do to address that? We've just put 3 points here. Clearly start to maintain your paper trail for decision making. Think now that TPR has got increased information gathering powers and certain information may have access to that information. To the extent that you're not doing so already, and I imagine the vast majority of employers are, please include your defined benefit pension scheme within your corporate governance considerations. Think about the corporate oversight requirements. Think about the new notification requirements that need to be met. And then finally, and really importantly, continue to engage sensibly and constructively with your pension scheme trustees. Document decisions and document any advice. And I think this is going to be really important in terms of course of conduct requirements around the criminal sanctions. If you look at one act in isolation, it might not have a particularly big impact on your pension scheme. But if it's part of a sequence of acts, it might have a big impact. You need to be thinking about not just the act itself, but that series of acts. So build that into your engagement with the trustees and your paper trail. So what does all this mean? Well, I think the headline for us, if you're looking at the Pension Schemes Act requirements in totality, is it's going to be really important to demonstrate as a corporate the implications of your actions and the impact they have on your pension scheme have been identified, been carefully considered, and where possible they've been mitigated. And I think if you take those steps, not only can you get on with your business day to day, you won't have to pay any material fines and you probably won't go to jail. So I hope that's been a useful introduction to the Pension Schemes Act. We've got a few minutes now for questions, so let's have a quick look at that. So we've got a few questions coming in here. I think, Liz, the first couple look like they might be for you, if that's okay. There was a bit of concern that dividends might be caught by the new powers. Does that seem likely?
Dividends. Yeah, I think this absolutely goes to some of the points that we've been talking about, Paul, around what's the extreme nature of the actions happening here. So, and I think certainly in the case of, for example, BHS, there were concerns in the media around large-scale dividend payments that had been made at relevant points before the scheme was particularly exposed. And I think it's clear that as a result of the way that these criminal sanctions have been drafted, that kind of behaviour might be subject to regulator scrutiny. But I think on balance, everything that we're seeing now coming from the regulator is around this being action taken by the regulator in extreme situations. So I don't think broadly dividends are going to be a problem per se, although nonetheless it's clear that they are on the regulator's radar. It's not just in these criminal sanctions, but also what we've seen from the regulator more generally talking about, for example, dividends. They are something that corporates need to be mindful of in terms of what the impact on the DB scheme might be. So they're not a no-no, but they're just something that, again, to that point around let's think about what the impact is and think about whether they're appropriate. It shouldn't stop that day-to-day business activity, but just be careful is probably the answer.
Okay. I think I might pick up on okay, Liz. For consultation with the scheme sponsor in respect to funding, what evidence should the sponsor and the trustee keep of that consultation? Well, I think there's some basic building blocks in there. Any minute of trustee meetings, any exchanges should ideally be through correspondence rather than verbal. Any advice that's been taken by the respective parties, if you keep all of that together, that should build quite a robust paper trail. Clearly, everything will determine by the circumstances, how difficult is the financial position of the sponsor, how underfunded is the scheme, how difficult have the negotiations been between trustee and sponsor. That will all affect the level of detail that's required. But I think those initial items I indicated, if you have that in place, that gives you a good starting point. And then another question, maybe for you, Liz. Do you think the regulator will try and prosecute the new offences and impose contribution notice at the same time?
Well, I think it's possible, but I think it also will depend on the circumstances. So there might be situations in which a regulator is unlikely to impose a contribution notice. So, for example, if the target's resources just mean that there's going to be inadequate money coming from the sponsor because of its financial situation. But it could be the case that the regulator nonetheless looks at prosecuting as a deterrent factor. So essentially to showcase the fact that that employer got it wrong and that might be in the public interest. And there's no doubt in terms of what the regulator is saying in the draft policy, there is that very strong deterrent element in these new criminal and civil sanctions. So equally, I think the regulator might choose to prosecute, not prosecute, but impose a contribution notice. I think it just depends on the circumstances.
Okay. Okay, let's find another one. What about trustee responsibilities? And I'll pick this one up, Liz. What about trustee responsibilities in a corporate reorganisation that doesn't directly affect its sponsor, e.g. the sale of an ultimate parent that hasn't got any legal obligation to the scheme? That's a difficult position potentially for trustees. I think all they can do as part of the information sharing protocol with their sponsor is ask for information about the wider group and how any reorganisation in the wider group affect the sponsor and its ability to meet its obligations to the scheme. If you haven't got a direct right of access to the other group companies, that can be awkward. But if you are genuinely concerned, I suggest all you can do is engage with the employer, engage with your advisors, and to the extent that you're still concerned, then maybe seek some support from the regulator. But it is difficult unless you've got a direct right of action against a particular organisation. You are then reliant on support from external parties. Let's see if there's another one. We are a major charity and part of the LGPS, over which we have little influence. Sorry. My bigger concern is our trading arm collapses during COVID-19, and that results in insolvency. Does our inability to continue to contribute to the pension deficit and towards a cessation liability meet the criteria TPR considers as negligent? We'd have to look at the specifics in more detail, but there are the thought no. If you're doing all you can to support your scheme and events outside your control, the impact of COVID, for example, or difficult trading conditions, are putting you in a very difficult financial situation. That there's a limit to what you can do. I think all I would say there is just actively engage with the administrative authority of the LGPS fund. We are aware of them being supportive of certain not-for-profits and charitable organisations, and where possible, giving them the breathing space, possibly through reduced contributions or through deferral of deficit reduction contributions. So there are mechanisms in place that will give you the breathing space potentially to steady the ship. I appreciate that's a difficult conversation to be having, and this is the very difficult question to have to deal with. I'll be happy to pick it up with you offline, but I think that's all we can say on the call for now. I think there's just one more question. Can you foresee a difference in the potential impact of the provisions in distressed restructuring transactions versus transactions higher up the covenant demise curve? I think so. I think the requirements are there, and they ought to be applied differently in different circumstances. Fundamentally, trustees and regulator and the majority of employers want the best outcome for their pension scheme that they are able to deliver in a particular set in circumstances. So if there's a very financially robust sponsor, the rules of the game are different for them. If you've got a sponsor in very serious financial distress, then clearly what they can be expected to deliver their pension scheme does change. So I think it just turns on the circumstances. But summary, yes, I think the requirements will be applied differently.
Yeah, and I think that goes to what was being said by the regulator in this policy around the incidental fundamental point test. So actually, if there are situations in which mitigation just can't be offered, and what was put in place was the only possible outcome for that employer in distress, the employer will take, the regulator will take that into account.
Okay, thanks, Liz. Well, it's nearly coming up to 1:45, so as if by magic, we've nearly completed the session on time. Now, can I just thank you all again very much for making the time to attend today. Thank you for being engaged and asking the questions that you did. I really hope the session's been of use. And if you have any further questions after the session's closed, please contact me and Liz. And just thank you again. And then before I get told off by our business development team, a final plug for the feedback form that'll be coming around very shortly after the session. We'd really welcome your comments. It'll shape our future events. So thank you all again. Enjoy the rest of your day.
Thanks, everybody.